Good day, ma'am. So we are the BS Criminology 3CA. For today's video, we are going to discuss about Act number 4103, otherwise known as the Indeterminate Sentence Law. The penalty imposed by the court is determined or straight if the court sentences the accused to suffer 9 years of prison mayor for committing frustrated homicide. He shall be imposed for a year's less credible preventive imprisonment time allowance. So, yan dati yung sinusunod natin, yung sentence na sinusunod is yung determinate sentence of law, hindi na siya yung straight or determinate. Naging indeterminate, ibig sabihin merong minimum at maximum. However, Act number 4103 has established the parole system, under which a convict may be released on parole after serving a portion of his sentence. To implement the parole system, the court under the law must fix the minimum penalty which the accused is required to serve to be eligible for parole. Dito, nabanggit kung bakit kailangang magkaroon ng minimum at maximum kasi nga meron na tayong parole system. Magkaiba yung parole at probation sa probation, hindi na isi-serve yung sentence mo muna. Magkakaroon ka ng subuklaya kapag ang parusa sa'yo ay hindi naman lagpas ng 6 years na pagkakulong, pwede kang mag-apply ng probation. So, ang kaibahan ng probation sa parole is sa probation, hindi ka muna or hindi ka na magsiserve ng iyong sentence. Magsiserve ka lang ng sentence mo kapag may violation ka, na-violate mo yung condition ng iyong probation, pero kung hindi mo na isi-serve, considered terminated na yon. Na yung probation mo, erase na ang iyong record. Sa parole system naman, kailangang ma-serve mo yung minimum number of years of imprisonment. Kaya nga yung indeterminate sentence of law, ito yung ini-implement at ang penalty mo ay reclusion temporal. Next, lower degree non-prison mayor. So, doon kukunin yung minimum na penalty. Yung maximum niya, yun na yung dapat na maximum din ng indeterminate sentence mo in fixing the minimum of indeterminate penalty. The court shall consider first, we have the age of the criminal, his mentality, heredity, and personal habits, his previous conduct, environment, and the mode of life, and criminal record if any, his previous education, both intellectual and moral, his proclivities and aptitude for usefulness of injury to society, his demeanor during trial, and his aptitude with regard to the crime committed, the manner and circumstances in which the crime was committed, the gravity of the offenses, relationship first toward his defendants, family, associates, and their relationship with him, and his relationship towards society at large and the state are important factors.
Provisions. Section 1. Hereafter, in imposing a prison sentence of an offense punished by the revised penal code or its amendments, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall be which, in view of the attending circumstances, could be properly imposed under the rules of the said code, and the minimum which shall be within the range of the penalty next lower to that prescribed by the code for the offense. And if the offense is punished by any other law, the court shall sentence the accused to an indeterminate sentence, the maximum term of which shall not exceed the maximum fixed by said law, and the minimum shall not be less than the minimum term prescribed by the same. So what is indeterminate sentencing? So indeterminate sentencing is a system of sentencing in which there is more flexibility in deciding what an individual's sentence will be. So usually the sentence is given in the form of a range with a minimum and maximum amount of time to be served. So as an example, if a judge sentences the convicted individual with a term of 20 years to life, and the individual would have to serve at least 20 years of a prison sentence. However, they may not have to serve a full life sentence depending on their behavior while in prison. The parole board has the discretion to release the prisoner earlier. So what are the difference between determinate and indeterminate sentencing? So determinate sentence is a jail or a prison sentence that has a defined length and can be changed by a parole board or other agency, while indeterminate sentences may be handed down for felony convictions where punishment includes incarceration in a state prison. They are not generally used when the crime is less serious.
The indeterminate sentence law is mandatory in all cases except in the accused will fall in any of the following exceptions. First exception is if the sentence with the penalty of death or life imprisonment. Second, if the convicted of treason, conspiracy, proposal to commit treason. Third, if the convicted of misprision of treason, sedition, rebellion, or espionage. 4. If the convicted of conspiracy. 5. If the offender is habitual delinquent. 6. Those who escape from prison or evade sentence. 7. Those who violate the term of conditional pardon of the chief executive. 8. Where the maximum term of misprison does not exceed in 1 year. 9. If the convicted by final judgment at the time of executive of Article number 4103, and the last exception is if penalized with suspension or distero.
Act number 4103, Section 2. This act shall not apply to person convicted of offenses punishable with death penalty or life imprisonment. To those convicted of treason, conspiracy, or proposal to commit treason, to those convicted of misprision of treason, rebellion, sedition, or espionage, to those convicted of piracy, to those who are habitual delinquents, to those who have been escaped from confinement or evaded sentence, to those who have been granted conditional pardon by the chief executive shall have violated the term thereof. To those whose maximum term of imprisonment does not exceed 1 year, not to those already sentenced by final judgment at the time of approval of this act, except as provided in Section 5 thereof. So, ang sinasabi ng Section 2, it shall not apply to persons convicted of offenses punishable with death penalty. Hindi ito yung mga taong mabibigat yung kaso na nahatulan na ng death penalty or life imprisonment, hindi sila pwedeng mag-apply for parol. Kinakailangan nilang pagbayaran yung mga nagawa nilang pagkakasala at hindi sila pwedeng mag-apply ng parol.
Good day everyone, I'm Larry B. Figueroa Jr. from BS Crim 3C Alpha, and now I will discuss the Section 2 of Provision, the non-institutional conviction. And let's begin. Section 3 is there will be created a board of pardons and parole to be composed of the Secretary of Justice, who shall be its chairman, and 4 members to be appointed by the President, with the consent of the Commission on Appointments, who shall hold office for a term of 6 years, provided that 1 member of the board shall be a trained sociologist, 1 a clergyman of educator, 1 psychiatrist, unless a trained psychiatrist be employed by the board, and the other members shall be persons qualified for such work by training experience. At least 1 member of the board shall be a woman. Of the members of the present board, 2 shall be designated by the President to continue until December 30, 1966. And the other 2 shall continue until December 30, 1969. And the other 2 shall, is in case of any vacancy in the membership of the board, a successor may be appointed to serve only for the unexpired portion of the term of the respective members. Section 3 is the extraordinary circumstances. The board shall be recommended to the President the grant of executive clemency when any of the following extraordinary circumstances are present. A is the trial court or appellate court in its decision recommended the grant of executive clemency for the inmates. Next is under the peculiar circumstances of the case, the penalty imposed is too harsh compared to the crime committed. C is the evidence which the court were free to consider before conviction, which would have justified an acquittal for the accused. And these the inmates who were often 15 years while under 18 years of age at the time of the commission of the offense. And inmates who are 70 years old and above whose continued imprisonment in inimical to their as recommended by a decision of the Bureau of Corrections Hospital and certified under oath by a physician designated by the Department of Health. Inmates who suffer from serious, contagious, or life-threatening illness, disease, or with severe physical disability, such as those who are totally blind, paralyzed, bedridden, etc., as recommended by physician of the Bureau of Corrections Hospital and certified under oath by the physician designated by the Department of Health. GST. Alien inmates were diplomatic consideration and amity among nations necessitate reviewer and such other similar or analogous circumstances whenever the interest of justice will be served thereby. In this, the national prisoner confined in a local jail. The board may consider the release on pardon or parole of a national prisoner who is serving sentence in a municipal city, district or provincial jail, unless the confinement inside jail is in good fair or due circumstances beyond the prisoner's control. Now, national prisoner for purposes of the rules is one who is sentenced to a maximum term of imprisonment of more than 3 years or to a fine or more than 5,000 pesos. Or regardless of the length of sentence imposed by a court to one sentence for violation of the customs law or other laws within the jurisdiction of the Bureau of Customs or enforceable by it, or to one sentence to serve 2 or more prison sentences in the aggregate exceeding the period 3 years. Thank you and God bless.
My name is Pilmar Iagoba from BS Criminology 3C-A. Good day everyone. I'm going to discuss with you about Section 3 under Non-Institutional Correction. Section 3 Meaning of Terms. A. Probation is a disposition under which a defendant after conviction and sentence is released subject to conditions imposed by the court and to the supervision of a probation officer. B. Probationer means a person placed on probation. Probation officer means one who investigates for the court a referral for probation or supervises a probationer or both who are qualified for probation. Probation is defined under the law as a disposition under which a defendant after conviction and sentence is released subject to conditions imposed by the court and to the supervision of a probation officer. Section 3 Probation Law. All persons who are sentenced for a crime are qualified for probation except those A. Sentenced to serve a maximum term of imprisonment of more than 6 years. B. Convicted of subversion or any crime against the national security or the public order. C. Who have previously been convicted by imprisonment not less than 1 month and 1 day and or fine of not less than 200. D. Who have been once on probation under the provisions of this decree. E. Who are already serving sentence at the time the substantive provision of this decree became applicable pursuant to Section 33 hereof. Purpose of probation. Probation is a privilege granted by the court to a person convicted of a criminal offense to remain in the community instead of actually going to prison or jail. What are the advantages of probation? The government spends much less when an offender is released on probation than that offender be placed behind bars, jails, or prisons. The offender and the offender's family are spared the embarrassment and dishonor of imprisonment.
Hello guys, I'm Richard Martinez and For today's video, I'm going to discuss the section 4. So, the word of pardon and parole ay pinapahintulutan na gamitin ang mga naturang alituntunin at regulasyon na maaaring kinakailangan para sa pagtupad ng mga pagpapaandar at tungkulin nito. Ang board ay binibigyan ng kapangyarihan na nananawagan sa anumang bureau, office, branch, subdivision, ahensya or instrumento ng gobyerno para sa naturang tulong na maaring kakailanganin na may kaugnayan sa pagganap ng mga tungkulin nito. Ang isang nakakarami sa lahat ng mga membro ay dapat bumuo ng isang quorum at isang boto ng karamihan ng kinakailangan upang magkaroon ng desisyon. So, yun yung ibig sabihin ng Section 4.
Hi guys, I'm Agustin Jasame. So, this video will be the continuation of Section 4. So, let's start. It is stated here that any dissent from the majority opinion shall be reduced to writing and filed with the recorder of the proceedings. So, ibig sabihin yung mga, anuman doon sa mga dissent na majority opinion, ay kinakailangan mag-reduce ng writing and file, kasama yung record ng proceedings. And each member of the board, including the chairman and the executive officer, shall be entitled to receive compensation 50 pesos for each meeting actually attended by him. So, yung mga bawat isa daw doon sa board, kasama na yung chairman at executive officer, ay makatatanggap ng compensation na 50 pesos kada meeting na ina-attendan nila. And now, notwithstanding the provisions of Section 259, the Revised Administrative Code, and in addition thereto, reimbursement of actual and necessary traveling expenses incurred in the performance of duties, provided, however, that the board meeting will not be more than 3 times a week. So, doon tayo sa reimbursement. Ang reimbursement ay yung action of repaying a person who spent or lost money. Ibig sabihin, yung kabayaran ng isang tao doon sa nagastos or nagamit na pera or nawalang pera ay kinakailangan i-incur doon sa performance and duties nila. And provided, sabi dito, yung board meeting ay hindi dapat more than 3 times a week. So, yun.
Hello guys, hello ma'am. Good afternoon. So I'm Mason Braille Walbas from Crim 3C-A. So for today's video, I'm going to discuss the Section 5. So Section 5, it says it shall be the duty of the Board of Intermediate sentence to look into the physical, mental, and moral record of the prisoners who shall be eligible to parole and to determine the proper time of release of such prisoners. Whenever any prisoner shall have served the minimum penalty imposed on him, and it shall appear to the Board of Intermediate sentence from the reports of the prisoner's work and conduct which may be received in accordance with the rules and regulations prescribed, and from the study and investigation made by the board itself, that such prisoner is fitted by his training for release, that there is a reasonable probability that such prisoner will live and remain at liberty without violating the law, and that such release will not be incompatible with the welfare of society. Said Board of Intermediate Sentence may in its discretion and in accordance with rules and regulations attempted hereunder authorize the release of such prisoners on parole upon such terms and conditions as are herein prescribed as may be prescribed by the board. So this is my explanation. An indeterminate sentence is a sentence imposed for a crime that isn't given a definite duration. The prison term does not state a specific period of the time or release date, but just a range of the such as 5 to 10 years. When it comes to such parole, shall show himself through physical, mental, and moral record to be a law-abiding citizen and do not violate any of the laws. However, it is very important to determine in order to apply the Board of Intermediate Sentence. A prisoner may be granted parole as long as he will prove to the board that he will abide the laws and his release will be compatible for the interest and welfare of society. Amos, it is a way of helping the offenses rehabilitate, redeem themselves, and constantly change for the better. So that's it. Thank you.
Good morning. My name is Attorney T. Magallanes Jr., Section 3C-A. I discuss the Section 5. The said Board of Indeterminate Sentence shall also examine the records and status of prisoners who shall have been convicted of any offense other than those named in Section 2 thereof, and been sentenced for more than 1 year by final judgment prior to the date of which this act shall take effect, and shall make recommendation in all such cases to the Governor General with regard to the parole of such prisoners as they shall deem qualified for parole, as herein provided. After they shall have served a period of imprisonment not less than the minimum period for which they might have been sentenced under this act for the same offense. Ang ibig sabihin nito, hindi pwedeng mag-apply ng parole ang isang prisoner na convicted ng misprision or of treason or rebellion or sedition or espionage. At hindi rin pwede mag-apply ng parole kung ang sentence sa'yo ay mas higit sa 1 year by final judgment. Pwede lang siya mag-apply ng parole kung ang sentence sa kanya ay pababa sa 1 year. Ano ba ang ibig sabihin ng parole? Ito ay isang pribilehiyo na kung saan pinakaloob ito ng isang tao nakagawan ng isang krimen pagkatapos nito pagkompleto ng unang bahagi ng kanyang termino ng pagkakabilanggo.
Hi guys, I'm Augustine Jasame A. So this video will be the continuation of section 4. So let's start. It is stated here that any dissent from the majority opinion shall be reduced to writing and filed with the recorder of the proceedings. So, ibig sabihin yung ano man doon sa mga dissent na majority opinion ay kinakailangan mag-reduce ng writing and file kasama yung record ng proceedings. And each member of the board, including the chairman and the executive officer, shall be entitled to receive compensation 50 pesos for each meeting actually attended by him. So, yung mga bawat isa daw doon sa board, kasama na yung chairman at executive officer, ay makatatanggap ng compensation na 50 pesos kada meeting na ina-attendan nila. And now, notwithstanding the provisions of Section 259, the revised administrative code. And in addition thereto, reimbursement of actual and necessary traveling expenses incurred in the performance of duties, provided, however, that the board meeting will not be more than 3 times a week. So, doon tayo sa reimbursement. Ang reimbursement ay action of repaying a person who spent or lost money. Ibig sabihin, yung kabayaran ng isang tao doon sa nagastos or nagamit na pera or nawalang pera ay kinakailangan i-incur doon sa performance and duties nila. And provided, sabi dito, yung board meeting ay hindi dapat more than 3 times a week. So, yun.
Good morning, I'm Rusty J.F. Barrett from Crim 3C-A to discuss the Section 6 of the Act number 4103 as amended by Act number 4225 and Republic Act number 403. It is stated that an act to provide for an intermediate sentence and parole for all persons convicted of certain crimes by the courts of the Philippines Island. So it is stated at Section 6 that every prisoner released from confinement and on parole by virtue of this act shall that such times and in such manner as may be required by the conditions of his parole, as may be designated by the said board of such purpose, report personally to such government officials or other parole officers hereafter appointed by the Board of Intermediate Sentence for a period of surveillance equivalent to the remaining portion of the maximum sentence imposed upon him or until final release and discharge by the Board of Intermediate Sentence as herein provided. The officials so designated shall keep such records and make such reports and perform such other duties hereunder as may be required by the said board. Limits of residence of such parole prisoner during his parole may be fixed and from time to time changed by the said board of its discretion. If during the period of surveillance such parole prisoner shall show himself to be a law-abiding citizen and shall not violate any of the laws of the Philippines Islands, the Board of Intermediate Sentence may issue a final certificate of release in his behavior which shall entitle him to final release and discharge. When we say intermediate sentence, it is intended to favor the accused, particularly to shorten his term of imprisonment depending upon his behavior and his physical, mental, and moral record as a prisoner to be determined by the Board of Intermediate Sentence.
So, ito po yung continuation ng discussion ng aking kasama. So, there is this span time called period of surveillance, and this is equivalent to remaining portion of maximum sentence imposed upon a prisoner or until his or her final release of discharge, which will be determined by the board. For example, the prisoner's penalty is 1 year to 5 years. The terminate sentence may be 1 year to 3 years, and the prisoner have stayed in the confinement or imprisonment for about 12 years. Therefore, his period of surveillance is 1 year. During this period, it is required to every prisoner released from confinement on parole by virtue by this act must report personally to any government officials um, or other parole officers only if this person is designated by the board of indeterminate sentence. And also, it is the decision of the board the extent of residence of the parole prisoner, which will vary from the time to time. Additionally, it is not only the parole prisoner has a requirement to fulfill. In Section 6, it is stated that the duty of the designated officials is to keep such records, make such reports, and perform such other duties which will be again depends on the requirement given by the Board of Indeterminate Sentence. Lastly, there are these conditions that parole prisoner must do during his or her period or of surveillance in order for the board to issue a final certificate of release, which we all know a certificate that entitles a prisoner the final release of discharge. One, to show himself as a law-abiding citizen, and two, shall not violate any of the law of the Philippine Islands. So that's it. Thank you.
Hello guys, I am Mark Geolog from Best Criminology 3 Journey. Okay, for this video, I'm going to discuss the Section 7, Article number 4103, which is the board shall file with the court which passed judgment on the case and with the Chief of Constabulary a certified copy of each order of conditional or final release and discharge issued in accordance with the provision of the next preceding two sections. Okay, sinasabi niya yung procedure kung paano ma-serve yung parole So, ang una, yung board ay mag-file sa court. At ang court na sinasabi ay yung court na nag-convict sa taong na aresto or the convicted person. So, yung Board of Resolution ay magpasa sa korte and the Chief of Constabulary ay a certified copy order of additional and final release. So, they will decide whether or not the prisoner is qualified for parole. So, meron pa rin certain requirements. Tapos, pag nabigay na yung parole, there is a conditions. For example, mag-attend ng community service and etc. So, Section 7 should be read with Section 8 and 9 because they are go together. Di pwedeng basahin yung Section 7 without Section 8 and 9. Dapat i-connect mo yung Section 7 kasi they are attached each other. So, yun po yung Section 7.
So, ano nga ba itong sinasabi sa Section 7? Section 7, the board shall file with the court which pass judgment on the case in which the Chief of Constabulary a certified copy of each order of conditional or final release and discharge issued in accordance with the provisions of the next preceding two section. Ang sabi dito na dapat mag-file ng board sa korte which pass judgment sa case together with the Chief of Constabulary na dapat na ipasa yung certified copy, either ito ay conditional or final, na humahatol sa akusado ng release order in accordance sa dalawang sinundang section.
Hi, I am Caliph Franz Ticada and I'm here to discuss about Section 8. Whenever any prisoner released on parole by virtue of this act shall, during the period of surveillance, violate any of the condition of his parole, the Board of Indeterminate Sentence may issue an order for his rearrest, which may be served in any part of the Philippine Island by any police officer. In such case, the prisoner so rearrested shall serve the remaining unexpired portion of the maximum sentence for which he was originally committed to prison, unless the Board of Indeterminate Sentence shall, in its discretion, grant a new parole to the said prisoner. It means any prisoner released on parole by virtue during the period of surveillance ay kung may na-violate any condition of his parole, the board will the board of indeterminate will may issue an order to rearrest the prisoner to serve in any part of the Philippine Island by the police officer. Any prisoner so rearrested shall serve the remaining unexpired portion of his maximum sentence for which he was originally committed to prison, unless if the board indeterminate sentence shall give or grant a new parole for the prisoner.
Section 8. Whenever any prisoner released on parole by virtue of his act shall during the period of surveillance violate any the conditions of his parole, the Board of Intermediate Sentence may issue of order to his rearrest which may be served at any part of the Philippine Islands by any police officer. In such case, the prisoner so rearrested shall serve the remaining unexpired portion of the maximum sentence for which it was originally committed to prison, unless the Board of Intermediate Sentence shall in the discretion grant a new parole to the new said prisoner. So according to the section 8, this is true. If you violated any rules when you are in parole, the parole or probation office can decide if you're going back again to the jail or rearrest you again even when the smallest thing you do outside. If you're under parole, small things matter. Example, people versus Orines. Orines is under in parole, involved in trouble, and the police knew that he is under parole. The police can rearrest him to go back again to the jail.
Hi, I'm Valerie Duldola from Section 3C-A. And Section 9, that all the property and right which may have been acquired in the Philippines island by the United States under the Treaty of Peace, except such land or other property as has been or shall be designed by the President of the U.S., and all lands which may have been acquired the provisions of Section 63 and 64 of the Act of Congress. They are placed under the control of the government of said islands to be administered or disposed of for the benefit of the inhabitants, and the Philippines legislature shall have power to legislate with respect.
Hello everyone, I am John Lloyd Tawaka from BS Criminology 3CA. Section 9. Whereas for the speedy accomplishment of such purpose, it is desirable to place in the hands of the people of the Philippines as large a control of their domestic affairs as can be given them without, in the meantime, impairing the exercise of the rights of sovereignty by the people of the United States, in order that, by the use of exercise of popular franchise and governmental powers, they may be the better prepared to fully assume the responsibilities and enjoy all the privileges of complete independence.
Hi guys, I am Patrice Maytonak of BS Criminology 3CA, and for today's video I will discuss to you the Section 10 of Act Number 4103. Section 10 is whenever any prisoner shall be released on parole hereunder, he shall be entitled to receive the benefits provided in Section 1751 of the Revised Administrative Code. Section 10 provides that when a prisoner shall be released on parole shall be entitled to the benefits of under Section 1751 of Republic Act Number 2711 or an act amending the Administrative Code of 1917 and not the new Administrative Code of 1987. Section 1751 is transportation and clothes for released prisoner. Upon the release of a national prisoner, he shall be supplied by the Bureau of Prisons with transportation to his home, including a gratuity to cover the probable cost of subsistence en route, and if necessary, a suit of clothes of the value of not more than 10 pesos, or in case the prisoner is deported, of not more than 40 pesos.